Come on, Soda Pop, let's go.
Item 37.
First reading an ordinance approving the Surface Ambulance Service Franchise Agreement between Paramedics Plus LLC and the City of Sioux Falls, South Dakota, along with authorizing the mayor to sign the same.
Yeah, Councilor Karski, thank you. Councilor Karski is going to recuse himself. This is a first reading. Thank you, David. Appreciate it.
Thank you, Mayor. Answering first Councilor Erickson's question, as we discussed at the 4 o'clock meeting today, there are no stays in place by any court at this point in time. We are urging a continuous operation of ambulance service 24/7, 365 that our citizens expect. If and until a court grants a stay of any kind, legally you can act upon this particular ordinance. The administrative enforcement stay that's being referenced and bandied about in the public media involves the administrative appeal ordinances regarding the stay of a fine or a penalty regarding an administrative enforcement action. This is not an administrative enforcement action in front of this body. You are approving the granting of an exclusive franchise, which is done under charter. It's not an administrative enforcement action, so there is no stay in place, Counselor, at this time. Does that answer your question?
Thank you.
If I may continue, Mayor?
David, please.
I will briefly describe what the contract before you is. It is essentially incorporating exhibits A and B are the request for proposals that was issued on July 18th of 2014, and then the Paramedics Plus response to that proposal dated October 9. And what the contract is very short on purpose because through the various meetings with stakeholders, you folks, all the public meetings, everything that took place, everyone agreed upon what should be in place for the requirements for this ambulance franchise. Those are all incorporated by reference into this contract. The contract itself contains very few additional terms beyond those exhibits. Probably a couple to be aware of is the protection of protected health information is a unique section in there, and that involves where about 10 years ago there were some issues involving where some medical services companies were offshoring some of the services, billing and the like to offshore companies. This prohibits that, and why it does so is that HIPAA, or our confidentiality laws, apply in the United States. This makes sure that that could never happen. Some other very brief things to keep in mind is this is a no subsidy system, as we indicated at the 4 o'clock. The Paramedics Plus LLC would be held to all the commitments they've made in both their RFP response and in the contract itself. This contract would be performed to the personal satisfaction of the city, which means they can't just perform at a minimum level, they have to perform at an optimum level. They've agreed to do so. There's a performance security bond of $1 million that would be immediately accessible in case there is a default by Paramedics Plus, and the city would need to go in, take over the ambulances themselves, run the service until such time as another provider could be provided. That provides us an immediate cash flow of $1 million to do that. The default and emergency takeover provisions really outline from the RFP exactly the types of default that would take place. Legally, I need to mention the indemnification provision that is also included in the RFP, where they are providing the city, you folks, everybody involved with either a REMSA board or the medical board, city council, city employees, all of us would be indemnified by Paramedics Plus for any lawsuit regarding their services they're rendering under this contract. We have the required civil rights section where they would be complying with our civil rights ordinances. They could modify the agreement only in writing. And then I think that covers it. If I'll let Jill then discuss exactly more of the detail. Thank you.
Jill, welcome.
Good evening. Jill Franken, Public Health Director for the City of Sioux Falls.
As you know, our current contract for exclusive franchise agreement for ambulance service ends May of this year. A council-approved audit was completed in 2013, and it recommended using an RFP process and also recommended contracting for professional services with an industry expert. We engaged with one of, if not the leading expert in the area, Dr. Jay Fitch with Fitch & Associates. When Dr. Fitch met with over 30 stakeholders, the following were the clear priorities for our community: that clinical quality was paramount, safety and response time performance matters, demonstrable experience providing high-quality EMS and capability of integrating into a complex healthcare delivery system. User fees were preferable to a subsidy to achieve the clinical service levels required and to maximize inclusivity of the applicant pool. We followed the American Ambulance Association recommendations and guidance, which is considered best practice guidance for requests for proposals, which this was referenced in the internal audit and also recommended by Dr. Fitch. We received 4 proposals. They were scored, and 6 of the 7 panel members scored Paramedics Plus the highest. Paramedics Plus leadership team, which is being brought for you in this contract for first reading, is led by Ron Schwartz. He's the president. He actually attended University of South Dakota, and he worked for the Vermilion Ambulance Service for a period of time. Mark Postma, who's vice president and actually is a Sioux Falls area native, and his parents actually live in Sioux Falls now. Mike Bureau will be the chief operating officer and just made Sioux Falls his home within the last week, and he is actually here in the audience tonight. He will run the Sioux Falls operation, and others on their leadership team that you'll become familiar with in the coming years, should you approve this contract. They are a sole provider in multiple geographically diverse regions. They serve over 2.8 million population. They have annual transports of over 270,000. They provide 911 and non-emergency service. Paramedics Plus scored high in quality performance, and some of the reasons for that is all their systems are CAS accredited, which is an accreditation we're familiar with our ambulance service currently operating. Unique, though, is that their Florida operation is actually triple accredited, not just CAS accredited. So 2 other accrediting bodies have also deemed them worthy of accreditation in Florida. They are recipients in Florida of the Sterling Award, which is based on Baldrige criteria, the highest award for quality won by a U.S. EMS agency. They also are recognized for their cardiac survival rates, being amongst the high in the nation in a couple of communities they serve. So the core requirements that they are being held to include response times, equipment and supply requirements, staffing levels of certification, licensure, clinical performance meeting approved medical standards, comprehensive quality improvement and compliance activities, dispatch performance standards, accurate and timely reporting, customer and community satisfaction. And then there's competitive criteria that they were scored on and are included in the RFP, and that's commitment to clinical quality, their operations management, their commitment to employees, management, administration, and EMS in the community. So with that, I am pleased to be able to tell you that we have worked very diligently on this approach. It's been highly inclusive and collaborative. We've used local and national experts, subject matter experts, and resources to execute an objective process for the residents of Sioux Falls. The aim is an exclusive franchise agreement requiring no subsidy, ensuring best practice, high-quality ambulance services will be provided to the residents of Sioux Falls. I want to thank the folks that are here tonight. There's some folks from our REMSA board, folks from our REMSA medical board. There's project team members that are here and stakeholders as well. So thank you.
Jill, thank you so much. David, thank you so much. Council, any questions, comments, motions?
I'll move to set the second hearing for Tuesday, February 10th at 7 p.m.
Second, Kylie.
Thank you so much. There's been a motion to set a date of hearing and second reading for Tuesday, February 10th. That was made by Councilor Rolfing, seconded by Councilor Kiley. Any discussion? Yes, Councilor Staggers.
Yes, Joe. The American Ambulance Association, you mentioned that you tried to follow their standards. Can you tell me, when it comes to standards, do they support the idea that when you do ambulance service on a non-emergency basis, let's say between one hospital and another hospital, it has to be just one ambulance service that does it, or can many do it?
Well, I'd have to, review exactly what they said in their guidance, but that is considered a necessary element of a high-performance EMS system, is to be able to assure that they are able to have exclusive rights to both 911 and non-emergent transport in order to be able to have enough transport volume in a community of our size to be able to be a viable entity, independent, and generating enough revenue to cover their costs.
Okay, because what we're dealing with here is a contract to provide for a legalized monopoly.
Correct.
That's what's going on. And I guess I'm wondering about that non-emergency transport. Am I correct or not? Did we used to allow an outside company come in and do non-emergency transport if the hospitals wanted that company? They didn't want it, they could have rural metro.
The only way they could provide it outside of this agreement are for any ambulance services that are not beginning and ending in the city limits, or that are provided through the VA, which has they are an exception to this, as well as the penitentiary. But otherwise, any ambulance service, non-emergent or emergent, beginning and ending in the city limits would be through the franchise agreement. That's been in place for many years.
Yeah, but my understanding is that we used to have a situation where we could have another ambulance company coming in and doing the non-emergency transport. And then a few years ago, the city decided, no, we're not going to allow that to happen anymore. And so then we gave that service completely over to rural metro.
That's always been a part of the exclusive franchise agreement, are all emergency and non-emergency transports beginning and ending in the city limits.
I mean, if the VA can get out of it and the penitentiary can get out of it, why can't Avera and Sanford get out of it?
Those are both entities that are, they have specific, I don't know, Dave, what you would call that.
It's a matter of recognition of sovereign power in terms of state government, federal government versus us.
Yeah, and we could go ahead and recognize Avera and Sanford as being private entities, that we're just simply going to allow them to make their own choice what ambulance service they want to have, instead of us
Counselor
telling
Stagers, I'm
them.
not recommending that. I'm recommending the contract that's before you tonight.
Right, but I'm just saying, we could, if we wanted to do that.
I'm not recommending that
Why not?
because of the reasons I've told you.
Because we want to give more money to the ambulance service that we're contracting with. I mean, that's what it boils down to.
Counselor Erickson.
Just for clarification, Attorney, can you address that? Because they are not sovereign, Sanford and Avera are not sovereign entities. It's not the state government or the federal government that are, am I following that right, or can you expand on that?
Yes, Counselor, they would be subject to the ordinance. And again, as we indicated at the 4 o'clock, the leadership of both Avera and Sanford Health Systems, as well as the Heart Hospital, were involved in discussions from the beginning with the consultant, Dr. Fitch, and they all were in agreement that this exclusive franchise agreement should continue as modeled in order to ensure the viability of the system. And I read off at the 4 o'clock certainly some Eighth Circuit case law and findings where if a private ambulance company is allowed to just come in beyond that exclusive franchise operating agreement, what happens is 911 calls suffer in terms of care and response times. And in that case, it was a specific Kansas City, Missouri case where in the late 70s and early 80s, the city of Kansas City was having extreme problems where a bunch of private ambulance companies were happy to take the non-emergency calls that were more profitable and leaving the city left to dry on a number of the emergency calls. And so the court found in particular that the exact same exclusive franchise model that we are operating under, where, as Jill indicated, the emergency and non-emergency calls originating and ending in the city are all covered by one provider. The Eighth Circuit specifically blessed that and indicated that it was perfectly legal.
Well, you know.
Counselor Erickson, you had the floor. Did you have any follow-up?
No, that's the line I was thinking, and I just wanted to hear it from you.
Thank you, thank you. Before I go back to Counselor Staggers, did you have any other comments before we move on? Very good, Counselor
I
Staggers.
was just going to say, you know, I'm not sure where that case came from that went to the St. Louis Circuit or Court of Appeals. We're Sioux Falls. We're a different community than probably, well, I know we're different from that community that was taken to the Eighth Circuit. But the thing I'm just trying to say here is that we're not mandated to create that monopoly. We're not mandated to do that. I don't know of any court case that mandates us to do that. All we're doing, or at least I think what should happen here, is at least we should have some competition.
We do.
And you can have some competition simply by allowing transport between the hospitals or however they want to do it. And, you know, for the argument that there were a couple of them represented in this process, well, they say they go along with it. Well, let them go ahead and go along with it voluntarily. They don't want to use another ambulance service, that's fine. But I don't see why we should be mandating Avera and Sanford as to what ambulance service they should take.
Counselor Anderson Jr.?
Fortunately, we don't license hospitals. That's one good thing here, like we do ambulance service.
Counselor Anderson Jr.?
Jill, just one question. Right now, is Rural Metro providing that non-emergency service for the hospitals?
Correct.
Thank you.
There's been very good discussion. A roll call vote, please.
Come on, Soda Pop, let's go. Come on, let's go. Come on.